Hello, everyone, and thank you for joining us today for our webinar on complying with the requirements of GPL LGPL v3 license. My name is Erica, and I'm going to be your host here today for the Zoom webinar Counsel. So before I hand it over and we start actually having the presentation that you guys came here to see, I'm just going to do a couple house cleaning items. First of all, we are recording this, and we'll be making the recording as well as the slides available within the next couple of business days. Secondly, if you have any questions, please put them into the Q&A. You should be able to see that at the very bottom of your screen. It's a little box with a Q in it, and along that black bar there at the bottom. We will be answering questions periodically throughout the presentation, but the majority of them we will hold until the end, and we'll answer them then. So with that, I'm going to hand it over to our speaker for today, who is attorney, mediator, and counsel to the QT company, Paul Criswell.
Thank you, Erica. Hello, everyone. Thank you very much for everybody taking time to listen to this today. As Erica mentioned, I am an attorney and mediator based in the Boston, Massachusetts area, and I've been working with technology companies for almost 40 years now. But as of right now, probably my greatest claim to fame is that I do act as counsel to the QT company, and I handle most of their legal work here in the United States. And so we are, I have lost my cursor. There it is. Okay. So let me talk a little bit about why we are here today. So beginning with version 5.7, certain modules of the Qt software, Qt open source software, will be licensed under the GPL and LGPL version 3. Previously, these modules were licensed under the GPL, LGPL version 2.1, and so there's a very significant difference there. In addition, the Qt company has announced that it is ending support for version 5.6 of the Qt software. So people that want to continue to have supported software will have to move to version 5.7 or higher, and because of that, they'll have to comply with the GPL version 3. Significantly, the GPL version 3 is a complete rewrite of the GPL license, and so it's important for developers to understand their obligations under this new set of licenses. And let me digress for a second here to kind of describe the ecosystem if I can. And I think it's important to understand that the goal of the open source community is the free and unfettered creation and use of software. It is not the proprietary creation and use of software, and it's not the coexistence of open source software with commercial software. Their ideal universe would see all software as being open source. And the coexistence of open source software with commercial software, I would suggest, is really a tactic, not a goal of the movement, or at least not of the true believers in the movement. And I'm not accusing anybody of anything that's dishonest or disingenuous in any manner, but rather that what happens is that that people create open source software. It's licensed under the appropriate licenses, and then it's up to the commercial entities and the lawyers for the commercial entities to figure out how the commercial software can coexist with open source software. But the goal of the GPL license is to achieve the 5 freedoms for software, not to make it comfortable to coexist. And so as commercial entities look for ways to make commercial use of open source software, the open source community has reacted. In some cases, they have found that those manners of use are perfectly acceptable. And in other situations, they've found that, or they are of the belief that what the commercial community was doing was really trying to subvert the purpose of open source software, and so they've tried to react to stop that in subsequent versions of the software license agreement. So that's one of the major elements of version 3 of the GPL. It closes a lot of the loopholes that people had found in previous versions of the license agreement. So as the world has moved to version 3 of the GPL, I think it's really significant to note that there are some companies that have simply blacklisted open source software that's licensed under the GPL 3. Companies that have a very open and considered view of the use of open source software, that allow open source software in their development, but who have decided that the terms of GPL 3 are simply not compatible with what they want to do with their engineering and with their IP management. And we'll talk a little bit about why maybe that is. As I said before, you know, it's the lawyers that really have to figure out whether there's a legal compatibility between the new license agreement and the commercial goals of the company. And as people have probably been able to observe, the legal community just gets itself up into a real snit about every couple of years over some issue that is going on. And we worked ourselves up over the Y2K scandal and decided that the world was going to come to an end on 1100, and it didn't. And then just as we were getting over that, then version 3 of the GPL came along, and things sort of settled down after that. And what happens? But GDPR comes along, and we work ourselves back up into a lather. But there's a reason for this type of reaction by the legal community, and that is that the lawyers hate uncertainty. Nobody wants to go into their lawyer, ask him or her a question, only to have them scratch their head and say, geez, I don't know what's going to happen there. And we are trained in rules of interpretation, we're trained in reasoning and analogy, and we are trained to be able to look at those guideposts to say, this is what the law is, this is what the situation is. In the GPL licenses, in open source software in general, but particularly with regard to the GPL licenses, a lot of those guideposts that we're really used to looking at are missing. You know, the language was drafted by people who are not lawyers, which that's not to say they can't write better than we do, but it's not language that feels familiar to us. And there's remarkably few cases, very little case law interpreting the GPL licenses. So it's really an area where there's very little guidance for us to be able to tell people, yeah, this is what's going on, this is what the law is. And that makes people very, very uncomfortable. And some companies have simply thrown up their hands and said, look, given the uncertainty of the interpretation of what's going on here, we are simply going to put GPL 3 software on our blacklist, and we are not going to deal with that. So I'm going to go through and talk about several different issues, the 4 that I think are the most important or the most prominent for you to understand as you're looking at whether you can comply with the requirements of the GPL 3 license. And that's number 1, the patent, how the GPL 3 deals with software patents, locked devices or the anti-TiVoization provisions in the GPL 3, source code availability, and then finally, something that's not particular to the GPL 3, but rather to the software open software community in general, and that's enforcement and developments in enforcement. And I promise you, if you hang on to the very end, when we're talking about enforcement, I've got a little bit of a kind of a kicker at the end of this that I think will bring a lot of things home to people. So that's my cheap and easy way of getting people to stay to the very end, but I think you'll find out that it's probably worthwhile. So let's talk about patents, because software patents are one of the chief areas where the open source community has said, hey, we have to put an end to this. This is a huge loophole in the philosophy and idea behind open source software. And the way it would work is this. I've got I'm creating a product. I am using GPL software to create that product. I'm very willing and happy to provide the source code to my product, to my customers, and so on down the line. But I have a patent on the technology that I have developed and I have put into this product. And so therefore, even though you have the source code and you have the knowledge and the physical ability to make changes to it, if you do, then you are in violation of my patent. You are infringing on my patent. And I can use that patent to control your use of my software and my product, much like people use simply providing object code to accomplish something similar. And that's something that the open source community thought was a complete anathema to the whole philosophy of what they were trying to do. So version 2.1 of the GPL, people used to say, has an implied patent license, meaning, oh, it's implied there that you can't give somebody your source code with the right to make modifications and then come back and accuse them of patent infringement. That we believe that is implied by law. Obviously not a sufficient answer for a lot of people, because as version 3 has come along, version 3 has a very explicit, detailed, and expansive patent license agreement in it. It is a full page and a half of, I would say, undecipherable prose. I will be honest with you, I have read and studied and given presentations about this numerous times, and I will tell you that if any lawyer looks at you and says, oh, I know exactly what this section means, I think they are just trying to justify their high hourly rate, because there's enough in this that is vague, that is contradictory, that nobody, I would suggest to you, can look at it and say, this is exactly what this means. And that's particularly true in a situation where there really haven't been many court cases that have interpreted it. So the basic premise of this software license is what I'll call a downstream patent. And if you use software that's licensed under the GPL version 3 and you provide that GPL code to your customers, and if you have a patent that reads on that code, and I'll get more into that in a minute, then you automatically grant to that person a patent license to do what is necessary in order to exercise the rights under the license agreement. Now, it's interesting. If you look at the exact language, what the exact language says is that you, as the licensor, are granting people a license under your essential patent claims. And essential patent claims are those that would be infringed by some manner permitted by this license of making, using, or selling its contributor version. So I'm not honestly sure what by some manner means, but I would suggest to you that that's pretty expansive and not necessarily precise terminology. The real key question, as I see it, is a patent contains, you know, various elements in the claim, and you have to be doing each of the things that's in the element in order to infringe. But do all of the elements of your particular claim have to be something that is found in the GPL software? Or can just one element of your patent claim be covered in that GPL in the GPL software, and the other elements are in the other aspects of your product? And I'd suggest to you that that's just not clear from the language of this license agreement. But it is absolutely the case that you don't necessarily grant people a license to every single patent that exists covering your product. Nobody is making that claim, but it's not really clear which patents that cover some aspect of your product you do license to people downstream. And then significantly, the license that you grant, when you grant somebody a license to use the GPL code, you grant them a software license that is irrevocable. It travels with the software, and I'll get to more of that in a second, and it includes future patents. So if I license you my GPL software today, and a year from now I obtain a software patent that covers what is done in that GPL code, you automatically, when that patent issues, you automatically get a license to it. So it doesn't matter if the license to the software took place long previously. And then, as I say, this travels with the software, meaning if my customer sells that product to somebody else, then that new person also has a license to my patent. And of course, the nightmare scenario that people worry about is for me to sell or license my software to somebody. With it comes a license under my patent, and then that customer sells it to a competitor of mine. And remember, then the competitor gets the source code because that's all part of the open source license regime. And they also have now a license to my patent under those circumstances. And that's part of the problem that people have with the patent the patent provision in the GPL 3. Let me also talk about patent cross licenses, if I will. If I may. And these are circumstances where you as the developer are part of an organization, a company that maybe has a license agreement with another company. So you are the licensee of their patent. And when you develop your product using the GPL code, the patent that you are the licensee of is an essential patent, has an essential patent claim that covers what you have prepared. And so you sell that. Well, you can't sublicense the patent necessarily, because you are just the licensee from somebody else. And you're between a rock and a hard place under those circumstances, because you can't comply with your license under, or with your requirement under GPL 3, because you're providing code. It has there are essential patent claims that you're licensed to use that you can't sublicense to somebody. And so the GPL 3 has a set of consequences under those circumstances. And the basic consequence, as I see it and as I understand it, is that you have to deprive yourself of the benefits of that license. And so oftentimes these licenses that we're talking about are corporate-wide reciprocal license agreements that one company has with another. And so have you now lost the entire value of your corporate cross license when you can't use the license that is that your company has obtained, but of course your company at the same time has granted licenses under its own patents to third parties. Finally, with regard to the patent license under the GPL3, I want to point out that people who are patent litigators, so the people that that either prosecute or defend patent infringement suits, have really started to focus on the licenses granted under the GPL3. I just recently read there's an article in the January 2019 American Bar Association Intellectual Property Litigation section publication by Andrew Strickland and Amy Chun that talks about if you are defending a patent infringement suit, that you really need to take a look at the plaintiff's use of open source software, because even if you're not licensed under that patent, there are significant issues that may help you to limit the damages that you're subject to, and it may even give you the opportunity to present defenses that might not otherwise be available. So if anybody is interested in this article, I won't get into a significant degree of detail because it gets into some pretty arcane legal details of the calculation of damages in intellectual property suits. But if anybody is interested, I will try to provide a link to that or a copy of that. Where I found it is behind a paywall. I'm a member of the IP litigation section, which is why I had access to it. But I'm certain that the authors would be more than willing to be able to share it with people. So if you're interested, then please let us know. But the bottom line here is that this is another way in which the automatic patent license of version 3 is causing companies that have their own significant patent portfolios to have some real agita about use of version 3 software. And one of the reasons that a lot of people have decided we're just going to put this on our blacklist, and we are not going to use it. Let me move on then to locked devices. And this is the relatively famous TiVo situation. Another workaround by the commercial community that version 3 has attempted to plug. What TiVo did and what other people were doing is they were creating devices, in TiVo's case, a digital video recorder. They we used open source software in developing this device. They were willing and happy to provide you with the source code that they had created, but their devices had intelligence within them that if anybody tried to modify the software that was contained within the device would shut down and would no longer operate. So rather than not providing source code, rather than trying to control you by using software patents, in this case, they attempted to use a technological lock to lock their devices if anybody tried to exercise their rights under the open source software license to modify the software. And the LGPL version 3 specifically prohibits this. It requires device manufacturers to provide effective installation means and instructions so that you can modify the software that is contained within the device, and you can then effectively install it and the device will still operate. But interestingly and importantly, this entire anti-TiVo section applies only to what are called user products. And user products are not the entire universe of technological devices, but they are also not just smart toasters and DVRs. A user product, and again, remember this anti-TiVoization prohibition applies to user products. It's a consumer product, meaning any tangible personal property that is normally used for personal, family, or household purposes, or anything that is designed for incorporation into a dwelling. So if you are creating a device, then and it is important for you to have this device be locked and unable, and have your customers, clients, competitors, whoever it may be, make them unable to modify the device, then you have to give some thought to, geez, what exactly is a user product? And I started talking about this, I could just feel half of the audience out there just kind of sitting back and saying, okay, I don't have to pay attention now, because clearly what I provide is not a user product, so this doesn't apply to me. But let me give you a couple of examples, because this may be a little bit more far-reaching than you think. Let's start with automobiles. One of the classic icons of American culture is the family car. Every family has their family car. And so how can you argue that the family car is not used for personal or family purposes? So given the potential legal consequences, how is it that, or how do you believe that automobile manufacturers or subcomponent manufacturers would feel about allowing customers to be able to modify the software that runs the safety features of the car, or something that governs the control systems, or something even something that controls the infotainment system? What happens if somebody's driving along and suddenly the infotainment system switches to massively loud music, and the person drives into a bridge pillar or something like that? What if people have the ability to modify the software and the navigation system, and somehow the navigation system leads them to the middle of nowhere in the middle of night? Clearly, the manufacturer would point to the fact that, hey, it was the modification that caused people problems, not me. But I think we all know that that's an uphill fight for automobile manufacturers to absolve themselves of liability under circumstances like this. Let me move on to medical devices. When does a medical device become something that's sold for personal reasons? What if what you're selling is a personal monitor, something that somebody wears all the time to monitor their heartbeat, to monitor their blood pressure, to monitor some other aspect of their health? What if you're selling an over-the-counter testing device that people use to test their blood sugar levels or their blood pressure or something like that? Are those really something that is sold for personal use? It certainly sounds like it. And what exactly then also is a dwelling? Because remember, this anti-TiVoization prohibition applies to anything that is sold for use in a dwelling. Now, I think it would be absolutely pushing it, and all of us would probably say readily that a hospital is not a dwelling. So probably if you're selling a surgical robot or something like that, then this is not something that would necessarily apply to you. But what about a nursing home? What if you're selling systems that are intended to be used in nursing home, defibrillation equipment or cardiac monitors or something like that? Is a nursing home a dwelling? People live there. People live there on a long-term basis. What about a group home? Well, a single family building in a residential neighborhood where half a dozen people live who are maybe recovering from some sort of addiction, or have some sort of common medical problem that they are all dealing with. And you sell equipment that is used by people that are in that particular group home. To me, that sounds like a dwelling. And I guess the other thing that I would point out is, even if today you're not selling something that would even arguably fit within any of these categories, are you limiting your ability to expand the range of your product line in the future if you build it on a software licensing model that requires you to unlock your device if you're selling it under certain circumstances? Okay, let me move on to source code, if I may. So, source, originally when open source software became a thing, there was what I always refer to as the raging virus warning. That if you used any bit of open source software anywhere in your product, that you would have to turn over all of your source code to every bit of your entire product line, to all of your customers, competitors, and whoever else might want it. And as the past 30 years have gone by, I think that raging virus warning has really been proven not to be the case. I mean, free and open software has succeeded beyond, I think, some of the wildest dreams of its proponents, and it's not ended up being something that that infects all of your commercial code and requires you to turn it over. We have developed some very regular and definitive customs as to how open source software can be placed side by side with commercial software, how they can interact with one another, in order for there not to be any sort of infection under those circumstances. I will say this: the language that describes that interface between open source software and commercial software is completely different in version 3 than it was in version 2.1, but I believe the effect is intended to be pretty much the same. That being said, some source code does have to be made available, and that is that the open source software that you use has to be made available in source code form. And if you don't modify it at all, then that requirement can be satisfied by people upstream, people where you got your source code to use the product. Or if you have provided modified open source software, then you have to provide the source code. So does this give somebody the ability to copy your user interface? And when we're talking about Qt software, we're probably talking about software that you're using to build your user interface. And is there value to your user interface that that is something that gives you an advantage in the marketplace? Were you perhaps the first mover in the market, and people are used to your user interface? And that's a competitive advantage, because people don't want to have to learn a whole new user interface in order to use your competitors' products. Well, what happens if they can simply go ahead and use and copy your user interface? Does it give somebody the opening to be able to provide some sort of third-party maintenance, third-party support for your device? Is it it used to be that there was a great deal of litigation and antitrust doctrine surrounding what manufacturers could do to prevent third parties from coming in and taking the maintenance business of things like office copiers away from them. And a lot of that sort of faded away as more and more of the value of these devices was in proprietary software. Well, does that come back then if what you're doing is using open source software, and then you have to provide source code to those third-party entities who are seeking to provide maintenance? And remember, this is all in the context of a situation where you've already granted a patent to any of these people that are getting your software. Because remember, we've got the GPL patent license that grants a patent and prevents you from being able to use your patents under these circumstances to protect your product. So let me go on to enforcement if I can. And this is not something that is really particular to the GPL 3 license, but there's been some developments in enforcement of free and open source software licenses that I think are important to people. So the traditional enforcement mechanism, the one that was intended, is enforcement by the copyright holder. So the entity that created the open source software is the entity that can enforce the license. And if you're not complying with the license, they can take legal action to stop you from any further use of the software. The one thing that I want to point out, and this is just a generic observation, not having anything to do with the Qt company in particular, and that is that in the case of dual licensed software, where you can get either a commercial version or an open source version, the entity that is the copyright holder is oftentimes the same entity, or at least they are related one way or another. So the entity that is providing the open source version really has an incentive to make sure that, hey, if you're using the open source version, then you really need to comply with your license obligations. Recent litigation in a case that's gotten a little bit of notoriety has added to the ability of people to be able to enforce, require people to comply with their obligations under the GPL. And a famous case involving Panasonic Avionics. And one of these really hard cases that makes really bad law, as the legal saying goes. Competitors of so Panasonic Avionics used GPL open source software to create some products. They were sued by some of their competitors, who accused them of a whole litany of antitrust violations, of unfair trade practices, and, oh, by the way, at the same time, of not complying with their obligations under the open source license that they had received. And what the plaintiffs alleged was that Panasonic's failure to comply with the GPL license was yet another unfair trade practice, was an antitrust violation that a competitor who was harmed could sue to seek redress. And as I say, this was a hard case because the accusations went far, far beyond the license agreement. But the trial court held that, okay, all of these allegations are allegations that can go forward, and we will at least give you the opportunity to prove that you, Mr. Plaintiff, have the standing to claim that the failure to comply with the GPL license is an antitrust violation. And then what happened is that after this ruling had taken place, the parties went forward and ultimately they settled the case. So what that meant was that no appeals court ever reviewed this finding. Never went up to the Supreme Court to have any of the higher courts pass on this. But this ruling is still on the books. Now it's by a trial court, a district court, which is not as strong a precedent as some other precedent, but it certainly puts a crack in the glass wall to allow other people to enforce the GPL terms. Customers, simply a question of if you've got a customer, you have warranted and guaranteed to your customer that you will comply with all of the documentation, as well as the license agreement part of the documentation. So if you don't comply with, or if they believe you're not complying with the GPL, they have the right to be able to sue you for a warranty claim or use it as a defense or a counterclaim. So those are all very, very significant developments in terms of the enforcement of GPL licenses. But now I want to come back to the thing that I really teased you with at the very beginning, and that is what I really believe is the final kicker with regard to the seriousness of complying with your obligations under a GPL license, and now GPL version 3. So think of this, everything seems to be going fine in your company. You've reviewed with your legal department your use of GPL version 3 software. You know, they're pretty relaxed about this. They are you know, letting you go ahead and do it. Upper management, you know, they're fine with this. You're getting the product out on time. It works, and you're sitting at your desk. You're having your lunch, and somebody from upper management walks in and says, "Guess what? Great news! We are being acquired. Some large multinational software company has made an offer for us. The offer is 3 times our present stock price. We're all going to be rich. Isn't everything wonderful?" And you're celebrating, and then they turn to you and say, "Oh, and by the way, they're coming in tomorrow to do their due diligence." Due diligence is a process that acquiring companies do to go in and really comb through the books and records of the company that they are acquiring to make sure that there aren't any problems that they are buying. So your boss's boss says they're coming in to do due diligence tomorrow. Have all of your records available with regard to how you are using software, particularly open source software and particular version 3 software. And so the court that you are making your case to now isn't a court of law, but it's people who are coming in to see if they think that there might be some sort of potential problem that they are acquiring if they decide to go ahead and buy your company. And I can tell you from experience that the people who actually do the mechanics of the acquisitions, they have one mentality, and that mentality is, I want to make sure nothing goes wrong after we buy this company. Doesn't matter to me whether anything good ever happens, but I need to make sure that nothing ever goes wrong. And so those people, as they are coming in and doing their due diligence, you'll have to prove to those people that you don't have an issue going on here. I had a client once, a software company was exactly this scenario. They were being acquired by a large multinational software company. They didn't really even have any issues with regard to their use of free and open source software. But the acquirer made them rewrite their product and get rid of every bit of software in that was licensed under a GPL license or something similar before they would proceed with the acquisition. So it can be a rather significant test and a rather significant burden at that time when you want to go forward with what everybody hopes is the event that that we've all been looking for. So I will leave it at that. I'll leave everybody to think about that. I just let me go back just once more and emphasize that you know, what I'm trying to get across is that there are, even though there are not monetary obligations when you acquire free and open source software, there are compliance obligations. There are compliance obligations that come at a price, that you have to do certain things to comply. And you don't have the insurance policy, you don't have the comfort of having a commercial license that will protect you under those circumstances. So with that, let me ask Erica if we can open the floor for questions. I know there's a few of them in the queue here, and I will just ask Erica if you can choose some questions, and let's take it from here.
Yeah, I'm working through here. There's a number of questions, so trying to find, just some themes that we can start working through here. So there's a lot of questions here about when we have to provide the source code to the end user. So there's the first one here is if you're using open source for B2B only, but not for B2C, do you have to provide the source code to the end user?
Simple answer to that is yes. The obligation to provide source code to the open source software is triggered by you distributing the software. So it doesn't matter if your customer is a consumer or if it's another business or whoever it might be. So let me just sort of put it into three different categories. If you are creating software and you're using open source software, then you have to have the source code for that open source software available to the customers to whom you distribute that software. And if you're not modifying the open source software, you can simply point them to the place where you got it. If you are modifying the open source software, then you have to provide them your own source code. So if you distribute that software to somebody, then the obligation is triggered. You can also create software that you utilize only internally, but you utilize it to provide services, software as a service to people. And there are obligations that attach to that you can't get around the distribution trigger by providing this as a service as opposed to providing it as a licensed product. But then the third category is if you are creating something that you will only use internally, then you're not distributing the software, and the source code requirements are not triggered under those circumstances.
Okay, great, thank you. The next one kind of along the when to make the source code available. So do you have to make the source code available to everyone or only the customers that you sell your software to?
It's generally only the people to whom you distribute the software. So, but for example, if that flows down, so that if you're providing software to a reseller or an OEM or somebody like that, then they will have similar obligations to their customers, and they may simply point people to you as the source of the modified open source software. So it's anybody who's downstream in your distribution or customer network, but it's not anybody in the whole wide world.
Great. So there's just a number, I'm going to summarize these a little bit here. There's a number of questions of people moving from 5.6 or 5.6 version of Qt or before, going to a more recent version. So can you just maybe go back and summarize again, like where the licensing differences come once they upgrade from 5.6?
Sure. If you're moving from 5.6 to 5.7 or newer, then your license to use the open source Qt is subject to version 3 of the GPL and version 3 of the LGPL. The differences are most significantly that there's an express patent license that's built into the version 3, that there's an express anti-TiVoization policy that's written into the LGPL 3. There's different language with regard to how you can let me just call it mash up your commercial software with the open source software, and then under what circumstance is there, does it make the entire thing open source or not? The language is different. I'm honestly not sure if there was intended to be a substantive difference or not, but the language is clearly different. So those are the major differences between version 2.1 and version 3. And by the way, I mentioned the LGPL license because want to maybe digress a little bit. I think I noticed some people were asking about that. So a lot of the libraries in the Qt code are licensed not under the GPL 3, but under the LGPL 3. So let me step back for a second. Under version 2.1, the GPL version 2.1 and the LGPL version 2.1 were two completely separate license agreements, had their own terms. Moving forward, the LGPL license is actually an addendum that's added to the GPL version 3. So all of the provisions of GPL version 3 apply, but there are what they generally call additional permissions that are granted by the LGPL addendum. And fundamentally, those have to do with a lot of these libraries that it gives you permission to, and this is vastly oversimplified, but I think you'll get the idea at least. The LGPL gives you the right to include these certain open source libraries in your commercial code without infecting your commercial code with the GPL obligations. So it gives you more permission to do more things with libraries that are licensed under the LGPL than if they were strictly licensed under the GPL.
Okay. I hope that helps answer a lot of these questions here on this. And, this is, maybe a little bit going beyond this too, but we do have someone here that's a consultant and they're using open source for a product they're developing for a client. So there's questions of, I think this is a little bit of open source versus commercial in that sense. Mm-hmm. And covering for consultancy, who needs a license, where does the license need to, how do they need to make sure their client is covered when we're doing this?
So if I understand the question, if the consultant is, so I guess there are two scenarios there. Number one, where the consultant is acquiring a license, they're building this product, and then they are passing that forward to their customer, who's mm-hmm. then offering it on the market. And under those circumstances, the customer would inherit any and all of the rights and obligations that the consultant undertook when the consultant signed up for the license. So if the consultant decided to use open source, then their customer would be required to comply with those open source obligations as they marketed the product. The other way that this could work is that the customer could be the entity that actually goes out and licenses the software, and the consultant merely comes in and does the work to build the product. I guess that's not merely, but the consultant comes in and does the work to build the product. Under those circumstances, obviously, the customer is the one that's acquiring the license, and they are subject to the obligations of whatever license terms they signed up for. I will say this, that under the CUTE commercial licensing term, commercial licensing terms, we specifically permit that client, that customer, to go out and acquire a CUTE commercial license and name consultants, contractors, whoever it is, as named developers who can use the software to develop a product under that license. I hope that answered the question.
I hope so too. It's a little bit, we might have to talk with you and figure out what the situation is there. I think we have one more question that we can do here until we get to the top of the hour, and this one's a little tricky here. So there's one that for a mobile app, if the source code is made available to the software downloaders on Google Play, is there, or there is no need to make it available even if it's open source? I think if I'm reading that correctly here. Or is open source code made available to software downloaders on Google Play?
I'm afraid you're beyond my knowledge there. I think that would really depend on the operation and the terms of Google Play, and I'm afraid I simply don't know that.
I think that's fair, and I think that makes a good point of just when you're doing the mobile apps, check where you're uploading it to, that you're still complying in that sense.
That's right.
So I think those are some of the big questions. I know there's we have a number of other ones here, and we'd be happy to follow up, and we'll be following up with some of these questions on here. Thank you everyone for joining, and thank you, Paul, for going through all of this with everyone.
Thank you. Thank you to everybody.
All right. Well, we hope to see you guys at future webinars. And if you have any questions about this or want any clarification, please reach out to us through the contact, and our reps will be happy to walk you through some of these topics. Have a great day.
Thank you, everyone.